With David Shapiro. David is a criminal defense attorney in San Diego, California, and he's agreed to answer some questions related to border drugs, transportation, and possession for sale. With that said, David, let's go into the first question that was posted. My son has been charged with transportation of controlled substance. He was stopped at the U.S.-Mexico border. Do I need a specific type of attorney for this charge?
Well, yeah, first off, your son needs a good attorney, preferably someone who knows what they're doing in criminal defense. And this may very well be a federal case or it could be a state case. It all depends. Here in San Diego, obviously, we border Mexico, so we deal with a lot of cross-border drug smuggling cases, whether it is far complicated or diverse, meaning multiple defendants, multiple organizations involved, or if it's simple, the client gets pulled over at the border or gets sent to secondary at the border and there's drugs in the car. So you definitely want someone who's handled these border types of cases before. And the other dynamic of it is whether or not the case will be prosecuted in state or federal court. Obviously, at the border, a lot of times the feds or in the U.S. Attorney's Office will pick up this case and prosecute this case. Sometimes, though, and increasingly more common for the lower amount of drugs, you'll see the case will be prosecuted in state court. If it's a San Diego County case, that would be in Chula Vista because that's the South County part of San Diego, which is the border with Mexico. So you definitely want someone who has the experience defending against drug cases in general, particularly in the courthouse, in the type of court, whether state or federal, what you're dealing with here, because these cases are defendable. You know, a lot of times people confess to the drugs, and that's usually not a good idea. But they are defendable even with the confession sometimes if circumstances match up. And there's a lot of things that a good and experienced attorney can do for your son.
Okay. Next question we had is, how does your pricing work for drug charges?
Well, my pricing for drug cases pretty much is similar to any other case. It depends on where the case is located, whether it's a misdemeanor or whether it's a felony, whether the case is in state court, whether the case is in federal court. Now, what stage of the case are we at? Meaning, has a preliminary hearing already happened? Has the client already pled guilty? Are we only dealing with sentencing? All those types of issues go into it. We're trying to be as flexible as possible, understanding that people don't save money in case they get arrested. Only, I guess, the real sophisticated lifelong criminals might do that. But, we're mindful of that, so we try and work with people as best we can on payments. We do offer payment plans from time to time if necessary and if they're mutually beneficial to both the client or the client's family and also to my office. I've said previously, we have a lot of leeway because it's my office and I can ultimately work with you as best as possible. Realistically, though, as a reasonable payment plan.
Okay, next question we had is more specific. Does the type of drug I possess matter, or does it matter more the amount of drug involved?
Well, they both matter, but the type of drug matters to a large degree, and here's the main reason why. If you come across the border, or if you're caught with 70 pounds of marijuana, okay, it's a possession of marijuana for sale. It's likely a transportation of marijuana charge in state court. Probation is in play if you're convicted, meaning you might walk out of this without having to go to prison, without having to do a significant, if any, actual jail time. But if it's 70 pounds of methamphetamine or 70 pounds of cocaine or 70 pounds of heroin, you're looking at far more serious charges. You're looking at more serious charges probably if you're dealing with 20 pounds of those drugs. Other than marijuana, there's also weight enhancements for certain controlled substances, which add on time to your underlying base offenses of possession for sale or transportation. So, in an ideal world of all the drugs, you probably want marijuana, especially if you don't know what's in the car. Meaning if you're like a blind mule, if you're just transporting drugs, no one told you, or you don't want to know what's in the car, probably your best bet and your safest bet is if it's marijuana. And obviously, because the same amount of drugs and marijuana, you'll probably wind up in a better sentence than something more hard and a different drug where prosecution might hammer you a little bit worse. So it definitely does matter.
Okay. Final question we had was no one can ever prove I sold the drug, or no one can prove I sold the drugs to anyone. So how can they say I possessed the drugs for sale?
Well, in order for you to be convicted of possession for sale or for the purposes of sale, they don't have to prove that you ever sold the drugs to anyone. A lot of times it's difficult to believe or far-fetched to say, the time you got caught, was the first time, but let's assume for argument's sake that's the case. What they look at is the amount of drug, the type of drug. So if you're looking at methamphetamine and you have 1.5 grams of methamphetamine, well, that could be for personal consumption. If you have 25 grams of methamphetamine on you, unless they're buying the Costco defense, buy in bulk type of a defense for personal use, they're going to look at some other things to try and make a case airtight against you. They're going to look at your cell phone if they have access to it to see if there's text messages talking about buying and selling of narcotics. They're going to look at whether you are making the mistake of having payo sheets, who's buying what, who owes you money, who paid, that type of stuff readily available that they can get access to, the law enforcement can get access to. They're going to look for packaging. If you're possessing 10 grams of a drug and you're like, hey, it's just for me, then why do you have all these little baggies, and why do you have 9 million scales, and why do you have all this other stuff, which would indicate that you're going to break that drugs down and break those drugs down and sell it on the street, or sell it. So all those factors go into it. The amount in and of itself is many times hopefully not enough to get you convicted of possession for sale, but you don't need to actually sell it. Sale of a controlled substance is a separate charge, a separate health and safety code charge in California from possession for sale. So, a lot of times we get that question a lot. Hey, I never sold to anybody. Well, that's good because that helps our defense. But, if you have all these other factors, like I said, scales, baggies, payo sheets, text messages indicating sales, if you admit that you were selling, high denominations of money on your possession, and consistent with sales, all those things aren't going to help your case. But at the same time, there's a lot of ways you can defend against those cases too, and that just stresses the importance on these types of cases, possession for sale cases, of making sure you have a quality attorney on your side. Another issue we've been dealing with here in California after Prop 47 in November of 2014 has been trying to negotiate these cases with the prosecution, because let's say you're charged with possession for sale of a controlled substance, whether it's cocaine or methamphetamine or heroin. Well, there was a time when, those charges in and of themselves, and they still are, non-reducible felonies. What means if you get convicted of that, it's a felony. You can never get a misdemeanor later over time. So the next step below that offense would be simple possession of the controlled substance. Now, simple possession of these controlled substances in November of 2014 are misdemeanors. So you're asking a prosecutor to make a jump from a non-reducible felony all the way down to a simple misdemeanor. And that's a jump that we've seen prosecutors don't like to do. So it's more difficult to actually settle these cases. And a lot of these times, they're not making much of an offer, which gives you all the incentive in the world to keep on fighting. And a lot of times, if they're not making you an offer, you got nothing to lose. Good things can happen if you fight on, especially if you have the right attorney on your side.
Excellent. Well, if you have any additional questions for David, all you need to do is post them to the comments section below. He's agreed to get back to you with answers. With that said, David, thanks for your time.
Yeah, my pleasure. Thank you.